I feel like I should spend the next 10 minutes or so praising Dean Enloe, but you already know what a great man he is and what leadership he's provided here and what a wonderful school he has taken a lead in building, but of course not all by himself, but the excellent faculty he's had working with him and with the aid of the staff, the student body and all. As I say, this is the 10th time I've been here. Usually it's been 2 weeks, sometimes 3, and I feel like this is a place that I call home. And I wish I could be here more than I am, but many commitments back home as well. Back at the Foundation for Moral Law, where I serve as the senior counsel and where we are regularly involved in cases involving the defense of religious symbols in public, the right of Christians to express themselves, the defense of traditional marriage, the defense of the sanctity of life, and other issues like this. Back there, we've had many interns from Handong that we have been very pleased with, and none that we haven't been pleased with. And if any of you are looking for an internship, either during the winter months or during the summer, we would be most interested in working with you. I'm up in room 206 upstairs when let's just say I'm there anytime I'm not somewhere else. And anyway, so stop by if you'd like to talk about it. And we'd certainly encourage you to visit Alabama. Now I'm going to tell you a little story that I have told before here, and most of you are new students and haven't heard this, so I'll just simply use it again. And that is that down in the southern part of Alabama, Alabama is right on the Gulf of Mexico, and we have some of the most beautiful beaches that you will find anywhere, and some of the nice warm water there and the like. Not all here, but during the summer months at least. But if you were to come and be an intern with our foundation, you'd have a few opportunities on weekends to go down to the beach. But there was a couple from way up in the northern part of the United States, South Dakota, where I'm from, and they decided in the middle of the winter months that they would book a luxury resort down there at Gulf Shores, Alabama. And so they booked that resort, and they were ready to go, and the day before they were to leave, the wife received an email message saying that she had to come in for a business meeting at her office the next day. And so they decided he would go ahead and fly down and she would join him the following day. Well, he flew down, and the resort was even more beautiful than he imagined. And he checked in, and first thing he did was take out his laptop and write an email to his wife, but he got a digit wrong on the email address, and it went instead to the widow of a South Dakota pastor whose husband had just died the day before. And she read the message, and she shrieked and fainted, because here's what it said. Dearest wife, just checked in. Everything's set for your arrival tomorrow. Eternally yours, your faithful husband. P.S. Sure is hot out here. Well, it isn't that hot, but you would enjoy a visit to Alabama. If you look to the lecture outline, I titled it, The 10 Commandments, Why Don't They Just Go Away? We have been having battles over the 10 Commandments in Alabama for almost since I arrived there in the early 1990s. A 10 Commandments display in the courthouse in Etowah County, then in the Alabama Supreme Court Judicial Building. And just a couple of weeks ago, the Alabama legislature just passed a constitutional amendment for the Alabama Constitution. And they passed it, but this means it has to go to the voters. They'll vote on this in November of 2018. And in the meanwhile, I'm sure there'll be quite a campaign over this. And it'll be an opportunity, particularly for us in the foundation, to take the helm, we'd like to think, and educate people about what the 10 Commandments really mean and why they do belong in courthouses, in public schools, and other public places throughout Alabama, and in fact, throughout the United States. Now, I'm not going to read all of the amendment. You can see it here, but part of the language, as you can see, says property belonging to the state may be used to display the Ten Commandments, and the right of a public school and public body to display the Ten Commandments on property owned or administered by a public school or public body in this state is not restrained or abridged. The civil and political rights, privileges, and capacities of no person shall be diminished or enlarged on account of his or her religious belief. No public funds may be expended in defense of the constitutionality of this amendment. The Ten Commandments shall be displayed in a manner that complies with constitutional requirements, including but not limited to being intermingled with historical or educational items or both, in a larger display within or on property owned or administered by a public school or public body. If this passes in November, and I think there's a very good likelihood that it will pass, I would virtually guarantee you that there will be a challenge filed against it. Probably first somebody would have to erect a monument somewhere, and then somebody else would challenge it in court. And most likely the argument that they would use is that, first of all, the Ten Commandments are a religious document and therefore do not belong in the public arena. But secondly, this is especially odious because of all religious documents. This singles out the Ten Commandments and the Ten Commandments alone and says that they may be posted and doesn't say anything about posting any other kind of religious document. I think there are some possible answers to that challenge, and the first thing I would point out, well, I remember one time when we had a Ten Commandments display in Alabama, and as that was being set up, I had a rather indignant reporter ask me, "How do you think a Jew would feel those Ten Commandments there?" I just answered, "Why don't you ask Moses?" The point is, first of all, the Ten Commandments are not only a Christian document. They were first a Jewish document. Muslims accept them, as do those of many other religions as well. Second point I would make, and this is probably more significant, is that they're not only a religious document. Now, if I were to say the Ten Commandments are not a religious document, that's something that I've had a hard time saying with a straight face, because no question they are a religious document. But the people who advocate an absolute separation, I think, take a very simplistic view of this, and they say that everything has to be either 100% religious or 100% secular, and there can be no middle ground in between. Well, Chief Justice Rehnquist, in a case in which back in 2005, Chief Justice Rehnquist ruled, and this is a 5-4 decision, but ruled that a Ten Commandments display on the Capitol grounds of the state of Texas was constitutional. This was a 5-4 decision. At the same time, there were 5 justices that ruled in a Kentucky case that a display there was not constitutional. But Justice Rehnquist, in his opinion in the Van Orden versus Perry case, said, of course the Ten Commandments are religious. But Moses was a lawgiver as well as a religious leader, and the Ten Commandments have an undeniable historical meaning. So my argument would be that, yes, the Ten Commandments are religious, but they're not only religious. They are also a legal code, a civil code, to some extent a criminal code, and a moral code. And certainly they have an influence on culture. I would note third that the Ten Commandments amendment does not prohibit other displays. It singles out the Ten Commandments, that is true, and says that they may be displayed, but nothing in this amendment says that other monuments addressed to, say, the Quran or to other religious documents may not be displayed. The reason, my fourth argument, that they have singled out the Ten Commandments is the Ten Commandments have been uniquely under attack. No other such monument that I can recall has been under the kind of attack that the Ten Commandments monuments have been under in the United States. And that's the reason I would argue that it is singled out. Also, I would simply note that the amendment requires that the Ten Commandments displays must conform to requirements set out in the Constitution, and I would assume this means cases that interpret the Constitution as well, such as they would need to be surrounded by other historical displays like maybe the Bill of Rights or the Declaration of Independence or other displays like this. But the final point that I would make here, and this I think is a very important point, is that the argument of equivalency here, that, well, if you allow the Ten Commandments, you've got to allow the Quran, and you've got to allow the Bhagavad Gita and the Vedas and these other documents. I don't believe that argument of moral equivalency really applies here, because the Ten Commandments have had a formative role on Western law and Western culture in a way that these other documents simply have not. And so the basic argument that I'm going to be making for you here is that the Ten Commandments are being displayed throughout the United States, in parks and many other places, not because of their religious significance, but because they represent a philosophy of government. The belief that is expressed in the American Declaration of Independence that a nation is established pursuant to the laws of nature and of nature's God, that all men are created equal and are endowed by their Creator with certain inalienable rights, and that this philosophy of law is what the Ten Commandments symbolize. In support of that argument, I would note first of all that the Ten Commandments summarize basic principles of law. First of all, respect for life. That's a basic principle of law that you will see in the laws of, as far as I know, every country on the face of the earth that prohibit murder, based on the view, thou shalt not murder, as we see it in the Ten Commandments. And the reason for that is that man is created in God's image, and therefore human life is of infinite value. Second, respect for property. And we see property rights respected in the Ten Commandments. First of all, in the command, thou shalt not steal. And you could possibly argue that that just means you can't steal from the state or you can't steal from the commune. But when you put that in conjunction with the last commandment, thou shalt not covet anything that is thy neighbor's, clearly this implies stealing private property as well. And so laws prohibiting theft and fraudulent or wrongful conversion and the like, all of these would be summarized by the command, thou shalt not steal. Respect for family. And we see respect for family in the command, thou shalt not commit adultery. Likewise, in the command, honor thy father and thy mother, and laws that support and back up the family certainly have their roots in this concept of the family, which is a divinely established institution. And then respect for truth. Now we see respect for truth in two of the commandments, thou shalt not bear false witness, but also in the command, thou shalt not take the name of the Lord thy God in vain, which, as Luther's catechism says, as the catechism of the Catholic Church and others throughout history have said, prohibits not only blasphemy, but also perjury and any kind of speech that makes light of God. And part of the reason for this is we recognize that in courts of justice, courts have to be able to arrive at the truth. You can't do justice apart from truth. If you have a person before you in court, your job as the judge is to determine whether that person deserves to be executed or jailed or fined or maybe set free or maybe rewarded. In order to know what is the just thing to do to render to this person what is due, you need to know the truth. Did the person commit the crime or didn't he? And if he did, are there some aggravating or mitigating circumstances we ought to consider in determining sentence? Anyway, so we need ways that the courts can arrive at truth. And that's one of the reasons we have our oaths and why we punish people for committing perjury. And finally, another value that I would suggest is in the commandments is respect for God himself. Because God is the author of civil government. In fact, all 50 state constitutions in the United States recognize God as the source of government. At the time our Constitution was adopted, Pennsylvania's Constitution even cited Romans 13 as the source for that proposition. Not only is God the source of governmental authority, But he is also the source of limits on governmental authority, particularly through the granting of human rights. And I have been to conferences of the Association of American Law Schools and gone through lecture seminars and the like, where they've tried to explain what the basis for human rights is and tried to explain it mutual self-interest and all kinds of explanations like this. And I've sat there and listened as patiently as I could and just wanted to stand up and shout, the only firm basis for human rights is the recognition that God has endowed us with unalienable rights. And unless they come from God, there is no authority for human rights at all. Now we can see in the Ten Commandments, the negative commandments convey positive rights, not positive rights in the sense that term is sometimes used, but in the sense that respect for life. The command, thou shalt not murder, conveys a right to life. Thou shalt not steal conveys a right to property. And so we see that idea there. And Justice Douglas was a very liberal Supreme Court justice, but he was also the son of a Presbyterian minister. And in a dissenting opinion, although the point that he's making here was not what the real issue of the case was, McGowan versus Maryland of 1961, Douglas said, the institutions of our society are founded on the belief that there is an authority higher than the authority of the state, that there is a moral law which the state is powerless to alter, that the individual possesses rights conferred by the Creator, which government must respect. Conferred by the Creator. If rights come from government, government can take them away. They're not really rights then at all, they're only privileges. We can only say they are unalienable rights if they come from a higher source than government. And what can that be but God? Douglas also said in 1952, and this was a majority opinion, where in Zorach versus Clausen, he said, we are a religious people whose institutions presuppose a divine being. Now, when we talk about these values being in the Ten Commandments and these values being in the Mosaic Law, I think we should recognize that one of the values seen in the Mosaic Law was that not only were they for Israel, they were a model for the rest of society. Moses declared in Deuteronomy 4, 5 through 8, behold, I have taught you statutes and judgments, even as the Lord my God commanded me, that you should do so in the land whither you go to possess it. Keep therefore and do them, for this is your wisdom and your understanding in the sight of the nations, which shall hear all these statutes and say, surely this great nation is a wise and understanding people. For what nation is there so great, who hath God so nigh unto them, as the Lord our God in all things that we call upon him for? And what nation is there so great, that hath statutes and judgments so righteous as all this law, which I set before you this day? Now, saying that the Ten Commandments and the Mosaic Law are a model for other societies, as Moses is saying here in Deuteronomy 4, is not simply to say that every nation should simply codify the book of Deuteronomy and make that their legal code. Rather, laws have to be applied to the society in which people live. E.C. Wines, who wrote a classic work back in the 1850s titled The Laws of the Ancient Hebrews. Fascinating book. But Wines makes the observation, civil laws, whatever be their source, to be adopted to the wants of any given community, must arise under, sorry, I lose my place here, must arise out of circumstances and be relative to certain specific ends, which ends, under other circumstances, it might be the heart of folly to pursue. Skipping over a little, he goes on to say, a wise legislator, whether divine or human, in framing a new code of laws for a people, will give attention to considerations of climate, of region, of religion, of existing institutions, of settled maxims of government, of precedent, of morals, of customs, and of manners, Out of these, there arises a general tone or habit of feeling, thinking, and acting, which constitute what might be called the spirit of the nation. Now, a lawgiver shows himself deficient in legislative wisdom, who makes laws that shock the general sentiment of the people, which are at war with the prevalent notions and rooted customs, laws which strip men of long established and favorite rights. Much more I could read there, but the point is, the principles of the Ten Commandments are of universal application. But the way you apply them is going to be different from one society into another. The framers of America established our nation based upon these principles, but they didn't apply them exactly the same way as they'd be applied in Israel. And as you seek to apply them in Korea, you'll need to recognize the unique history, the unique culture of Korea, and apply these absolute principles in light of the circumstances of the community in which you live. Anyway, so first point then being that the Ten Commandments summarize the basic principles of law, meaning that they're not merely a religious document. They are that, but they are also much more. Second point I would make is that the Ten Commandments are commonly used in American courts. Now, back in 2002, I did a Lexis search, and you all know about the use of Westlaw and Lexis. I just happened to use Westlaw on this particular occasion, and tried to find out how often the Ten Commandments have been cited. Now, as you can see from the handout here, I came up with 1,106 cases of record. By cases of record, we mean federal cases and state Supreme Court cases, and occasionally cases that might be in appellate courts within the state. And I don't believe that I got all of them by any means. If I had, I just put in Decalogue, Ten Commandments, and then I put in the King James wording of each of the commandments. If I'd used different wordings of each one, chances are I would have come up with many more. But one case in particular that I thought was very interesting, 1899, Moore versus Strickling, dealing with the West Virginia Supreme Court. Now, this involved a man who had been fired as a state employee because of the fact that he had solicited a prostitute. State law said that he could be fired from his position for something like this only if it was an act that constituted moral turpitude. And the question then is soliciting a prostitute moral turpitude? Well, the Supreme Court of West Virginia said yes, it is, because it is prohibited by the Ten Commandments. And look what they said about the Ten Commandments. These commandments, which, like a collection of diamonds, bear testimony to their own intrinsic worth, in themselves appeal to us as coming from a superhuman or divine source, and no conscientious or reasonable man has yet been able to find a flaw in them. Absolutely flawless, negative in terms, but positive in meaning, they easily stand at the head of our whole moral system, and no nation or people can long continue a happy existence in open violation of them. And again, there are well over 1,000 other cases that I could mention here in which the Ten Commandments has been cited. Ten Commandments also, my third point would be that the Ten Commandments and the Hebrew law they represent are the primary source of models of republican government. At a time when people were looking for models for republican government, they often looked to the Greeks and to the Romans. But John Adams, the second president of the United States, and I would argue perhaps the greatest scholar ever to sit in the White House, edging out Thomas Jefferson slightly because Adams' scholarship was much broader. But Adams, reading one of the French philosophe's books, Condorcet, wrote a note in the book in which he said, "As much as I love, esteem, and admire the Greeks, I believe the Hebrews have done more to civilize the world. Moses did more than all their legislators and philosophers." In 1816, he wrote to F.A. Vanderkamp, "The Hebrews have done more to civilize men than any other nation. God ordered the Jews to preserve and propagate to all mankind the doctrine of a supreme, intelligent, wise, almighty sovereign of the universe, which is to be the great essential principle of morality and consequently of civilization. And in a letter a few months later to Mr. Vanderkamp, he added, the Hebrew unity of Jehovah, the prohibition of all similitudes, appears to me the greatest wonder of antiquity. Well, you might wonder, what does the Hebrew idea of one God, what does that have to do with law? Simply this, that if we believe there is one God, then there is one truth, and there is one law. If you are a polytheist believing in many gods, then Jehovah, this God of the Hebrews, may have produced one law code, and maybe Marduk of the Babylonians gave another law code, and Ra of the Egyptians gave another, and maybe Wotan of the Germans gave still another code, and you have all these conflicting codes because each of them comes from a god. But if there is one God, there is one truth, and there is one law. Well, let's go on to look to the early Western uses of Hebrew law. One of the first to suggest to the West that they should look to the Hebrew model was Flavius Josephus. Now, Josephus was Jewish, but in his thought he was probably more Roman than Jewish, but his work, Antiquities of the Jews, is a classic of what Jewish history was and supplements the Bible to some extent, although it certainly isn't expired, not expired, inspired like the Bible is. But around AD 70, he suggested to Romans that the Israelite society could be regarded as a politia, that is, a constitutional body politic, and that Moses could be viewed as its lawgiver. We look to St. Patrick. Now, St. Patrick, fascinating figure, and you think of him simply as this Irishman who made beer turn green and make snakes disappear and things like that as he came to Ireland. Truth is that he was actually part Roman and part British, and he came to, I'm not going to go into the whole story, but he came to Ireland to evangelize Ireland, and by the time he died, Ireland, which had previously been almost entirely pagan, was mostly Christian. Now, one thing he would do as he traveled around Ireland, he would make copies, handwritten copies, of the Mosaic Law, a little book that he called the Liber ex lege Moisi, that is, the book of the laws of Moses. Now, obviously it wasn't a complete copy, but he would pass these on to the Brehon or Druid judges as he continued to work to convert people to Christ. Now, another thing, shortly before he died, he was asked by the High King to head a commission that would draft a written legal code for all of Ireland. And this commission was put together. It was 3 Christian bishops, 3 Druid judges, and 3 lesser-ranking kings. And they put together a code of laws, and as the law code is called the Senchus Mór, or the Great Law from the Gaelic, as the introduction states, it was then that all the professors of the sciences in Erin were assembled, and each of them exhibited his work before Patrick in the presence of every chief of Erin, that means Ireland. Now in the judgments of the true nature which the Holy Ghost had spoken through the mouth of the Brehons, that was the Druid lawyers, and just poets of Erin, from their occupation of this island to the reception of the faith, were all exhibited by Dubthach to Patrick. What did not clash with the Word of God in the written law and in the New Testament, and with the consciences of the believers, was confirmed in the laws of the Brehon by Patrick, and by the ecclesiastics and the chieftains of Erin, from the law of nature, for the law of nature had been quite right, except for the faith and its obligations, and this is the Senchus Mór. In other words, what Patrick is saying we did here is we looked to the common law of the Druids, and except where it contradicted Scripture, we followed it. And for the most part, it was consistent with Scripture, so we left it as it was, and put that together into a document that was known as the Senchus Mór, which was the governing document of law in Ireland for over 1,000 years. Or we can look to Alfred the Great. Now, Alfred the Great, King of England, in 890 AD, he drafted a legal code, the first written legal code to govern all of England. It was called the Book of Dooms. Doom is an old Anglo-Saxon word meaning law or judgment. And he began it with a recitation of the Ten Commandments. Now, Thomas Jefferson tried to suggest that that was a later addition. Just a Story and others, I think, very well refuted Jefferson on this. And one of the things they noted was that if a later monk had put that into the code, he would have used the Latin, whereas Alfred used the Syriac version of the Ten Commandments. Anyway, another value of the commandments. Now, another point here. Some of you probably heard of this great figure of the Middle Ages, Maimonides, a Jewish rabbi actually known as Moses ben Maimon, who lived from 1135 to 1204. Of his many, many accomplishments, one was the drafting of the Mishnah Torah, where he took the commercial law of the Old Testament and put it into the form of a legal code. And this was adopted as the commercial code for much of Europe. And one of the reasons for this is simply that at that time, the Pope of Rome had prohibited usury. That is, as he defined usury, it was charging of interest, and you could not lend money at interest. But the Jews didn't understand those Old Testament passages the same way. They said that this prohibition applied only to lending money to strangers, the stranger in the land, the foreigner whose car is broken down, or the widow, the orphan, the indigent, only people who are disadvantaged. To lend money to them was to be considered an act of charity, and you shouldn't profit from it. You should be thankful if you get your money back at all. But as far as just an arm's length business transaction to somebody who just wants money to expand his business, the Jews said that the prohibition on usury does not apply to that kind of loan. Well, what this means then is that if you wanted a loan, you would go to the Jewish sector to get your loan, and as a result, the Jewish commercial law becomes the commercial law for much of Europe. Now let's move on from there into the period of the Renaissance and the Enlightenment, which also tends to coincide in time with the Reformation. At the time of the Renaissance, we start seeing the modern idea of the state developing in Europe, and with that idea of the state comes the idea of a state with absolute power. We see King Henry VIII in the 1500s advocating a monarchy with absolute power. Then we see it under the Stuart kings of England, James and Charles I, and then Charles and James II, and arguing the divine right of kings, that the king gets power directly from God, and therefore his power is virtually absolute. Meanwhile, on the continent, we see King Louis XIV insisting on absolute power, and statement that has been attributed to him, although we're not sure he actually said it, "L'État c'est moi," or "the state, it's me, I am the state." We see similar things happening in Germany, the Holy Roman Empire, where this is moving from being a loose, decentralized collection of states to becoming an empire with the Prussian Union. And we see it in the writings of others like Thomas Hobbes, and I'm just giving a few examples. Hobbes with his work Leviathan, where he suggested the modern state has to be a state that has absolute power. But those who wanted republican governments strongly reacted against this. And some of these were the Protestant reformers. Luther, as you may know, had studied law. He studied law, and shortly before his law studies were completed, he was traveling home in the thunderstorm and was worried about being struck by lightning, and he made a vow to St. Anne that if he could return home safely, he would give up his legal studies and become a monk. Some of us have suspected that he might have made that story up because he didn't want to take the bar exam. But nevertheless, Luther had quite a law background, and he was a strong supporter of the old Anglo-Saxon common law against the encroachments of the Holy Roman Empire, which was trying to insist on the centralized forms of the old Roman law. Now, Luther would not go as far as some in applying the Old Testament to government today. He said some of the Old Testament law is, in his German term, Sachsenspiegel, that is, law that is unique to one community, that is, to Israel. But some of it is also what he called Recht, or that is, eternal principles of righteousness. And the Ten Commandments, he said, are in that category. Luther said on one occasion, natural law is the Ten Commandments. It is written in the heart of every human being by creation. It was clearly and comprehensively put on Mount Sinai, finer indeed than any philosopher has ever stated it. Natural law, then, is created and written in the heart. It does not come from men, but is a created law to which everyone who hears it cannot but consent. In our historical and theological foundations of law class, last night we were talking about natural law and how there could be law before the Ten Commandments were given. And the answer to that is that the Ten Commandments contain principles of law that summarize natural law in general, and that these principles exist from the beginning. As Luther said on another occasion, the Decalogue is not of Moses, nor did God give it to him first. On the contrary, the Decalogue belongs to the whole world. It was written and engraved in the minds of all human beings from the beginning of the world, like Paul says in Romans 2, the law of God written on men's hearts. 1524, we see the birth of Carlos Sigonius, an Italian Renaissance scholar, who wrote a work titled The Hebrew Republic, in which he explained the principles of the Hebrew Republic and contrasted it to what he written in other sources about the Greek republics and about the Roman Republic, which of course became the Roman Empire. Shortly thereafter, we have Peter Cuneus, a Dutch scholar, a legal scholar. He wrote a book by the same title in the 1500s, The Hebrew Republic, and in that work, he calls Moses the first to write and publish laws so that people might learn what was right and what was wrong, and which sanctions might steady the state Almighty God had ordered to be set up in Palestine. But it's not just for Palestine itself, he says. As he says on page 6, I ask you, illustrious members of states, to study over and again the Hebrew Republic, the holiest and best of all, which I have described in this book. It contains ideas that kings, leaders, and the administrations of republics may adopt for their own use. Johannes Althusius, writing in the early 1600s, professor of law and theology and philosophy, author of a work called Politica, that, I don't know, do you have that in the library here? Of all the various Calvinist writings, Althusius probably does more to talk about the biblical ramifications, the various scriptural provisions as they would apply to government. And to just summarize, he says the precepts of the Decalogue are included to the extent that they infuse a vital spirit into the association and symbiotic life that we seek, and that they prescribe and constitute a way, rule, guiding star, and boundary for society. If anyone would take them out of politics, he would destroy it. Indeed, he would destroy all symbiosis and social life among men. Hugo Grotius, a man who is sometimes called the father of international law. He was a Dutch diplomat, scholar, theologian, author of one work called The Right, or more commonly I see this titled The Law of War and Peace, talking about international law. But another work that he's less famous for, but that was probably more foundational, is The Truth of the Christian Religion, which has been described as the first Protestant work of Christian apologetics. And arguing in The Truth of Religion, he says, the most ancient Attic laws, from which the Roman laws were afterward taken, owe their origins to the law of Moses. And he argues in The Law of War and Peace that the law of Moses is very helpful in understanding natural law, and therefore it is relevant to international relations, even when in international relations we're dealing with some nations that are Christian and some nations that are not. John Selden is a name that's probably less familiar than some of these others, but far more important than most people realize. John Milton called him the chief of learned men reputed in this land, that is England. in the 1600s. He was a member of Parliament. He drafted the Petition of Right. He was a Christian, but he's primarily known as a Hebrew scholar. And he wrote extensively about Hebrew law. And his main significance is that he provided a basis in Hebrew thought upon which later thinkers could build republican concepts of government. He also insisted that there was great parallel between the Anglo-Saxon system of laws and the Hebrew system of laws. And in fact, the king placed him in the Tower of London for 5 weeks because he had insisted that the English Parliament was not created by the king and was not dependent on the king, but rather was an extension of the old Anglo-Saxon Vitana Gemot, or Parliament, and had ancient origins and therefore was independent of the king. He's right, but the king didn't like that. Now, of course, we're very familiar with Sir William Blackstone here. You have the Blackstone room upstairs, and Blackstone's commentaries on the laws of England categorized law as revealed law, the law of nature, municipal law, meaning human enacted law in general. But when he talks about the law of nature and the revealed law, he says that the revealed law is found only in the Holy Scriptures. The law of nature is the law of God, but it's revealed to us through human reason. But he says, undoubtedly, the revealed law is of infinitely more authenticity than the moral system, which is framed by ethical writers and denominated the natural law, because one is the law of nature, that is, Scripture is the law of nature expressly declared to be so by God himself. The other is only what, by the assistance of human reason, we imagine to be that law. If we could be as certain of the latter, the law of nature, as we are of the former, the revealed law, both would have equal authority, but till then, they could never be in any competition together. In other words, he's saying, we know what Scripture says, we are only thinking and conceiving what the law of nature says. So if there appears to be a conflict between them, we go with the law of Scripture. And he says, upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human law should be suffered to contradict these. Well, now I'd like to talk just a little bit about a couple of current works that I think are of great significance. One of these is by Joshua Berman. Now, Dr. Berman is a professor and lecturer at Bar-Ilan University in Tel Aviv, and he's written a most interesting book titled Created Equal: How the Bible Broke with Ancient Political Thought, published by Oxford in 2008. And as far as what we say in our Declaration of Independence in America, we hold these truths to be self-evident, that all men are created equal. Berman says, if there was one proposition that the ancient world considered self-evident, it was that all men are not created equal. That you have class distinctions and all sorts of distinctions among people. And he says Greek and Roman thought focused on how to make these classes work together and live in one society, but they made no effort to eliminate those classes or other distinctions. And he says, while ancient Greece is often considered the cradle of modern political thought, the patrimony of modern political thought rests no less squarely in the texts of the Bible, particularly the Pentateuch, that is, the first 5 books of the Bible. He goes on to say, the political philosophy of Deuteronomy represents an early and important chapter in the history of constitutional thought and the Western notion of a constitutional monarchy. And further, he says, central to Republican schemes, and Deuteronomy is no exception, is the notion of a mixed government and a degree of separation of powers. I will locate Deuteronomy's conception of a mixed government along the spectrum of theories of mixed government that have been proposed in the annals of Western political thought. Now here's another most interesting work. You've seen this title before with previous authors, but this is by Eric Nelson. Dr. Nelson is a professor of government at Harvard, and titled The Hebrew Republic, subtitled Jewish Sources and the Transformation of European Political Thought. He says, following Aristotle and other classical authors, political theorists acknowledge the existence of several correct constitutional forms, monarchy, aristocracy, and polity, later termed republican government, which they distinguish from the corresponding incorrect degenerate forms: tyranny, the bad side of monarchy; oligarchy, the bad side of aristocracy; and democracy, the bad side of republican government. In the middle of the 17th century, however, we find Republican authors making a new and revolutionary argument. They now begin to claim that monarchy per se is an illicit constitutional form, and that all legitimate constitutions are republican. This rupture was provoked by the Protestant reception of a radical tradition of rabbinic, that is Jewish, biblical exegesis, which understood the Israelite request for a king in 1 Samuel as an instance of the sin of idolatry. And he goes on to say, for roughly 100 years, from the time of Bertram to the time of Spinoza, European Protestants made the Hebrew Bible the measure of their politics. They believed that the same God who thundered from Sinai and who later sent his Son into the world had revealed to Israel the form of a perfect republic. They labored with the help of their rabbinic authorities to interpret his design and attempted in their own societies to replicate it as closely as possible. In the process, they made crucial contributions to the political thought of the modern world. Republican exclusivism, redistribution, and the toleration have all been defended on different grounds in the intervening centuries, but in the beginning, all were authorized by the divine will and made manifest in the Constitution of the Hebrew Republic. I'll just mention Shalev very quickly. He's a professor at the University of Haifa in Tel Aviv. And anyway, he has an interesting book titled American Zion, the Old Testament as a political text from the Revolution to the Civil War, that is, from the 1770s up until the 1860s, and talks about how the Old Testament shaped political discourse in America during this period of time. Well, my conclusion out of all of this is simply this, that the Ten Commandments are religious, but they are not only religious. They are also a moral, civil, criminal, and legal code that summarize the Hebrew law which formed the philosophy of republican government. I teach courses for the Oak Brook College of Law in California. Our academic dean, Robert Barth, wrote an article a few years ago, it's in the Oak Brook College Journal of Law and Government, in which he said, if you combine the philosophy of government of our founders with the form of government chosen, you create a republican form of government that presupposes a creator as the source of unalienable rights and the definer of human dignity and equality. This form of government acknowledges the existence of the creator as a self-evident truth, and yet recognizes the distinct differences between the jurisdiction of the church and the civil government. While the existence of God may be part of one's personal faith, the founders made a distinction, and this is very important here. The founders made a distinction between acknowledging the Creator as a matter of political philosophy and the manner in which one chooses to worship or fulfill his or her duty to that God. This jurisdictional separation between the acknowledgement of God as an essential proposition of good government, unalienable rights, equal protection, due process, and, on the other side, matters of worship, faith, and religious practices, is the essence of the legitimate separation of church and state. Those of us who would support this amendment in Alabama are not seeking to repudiate the idea of separation of church and state. In fact, I would argue that the oldest example of separation of church and state that we see in the world is found in Old Testament Israel. For the religious authorities, the king, the priests, always come out of the tribe of Levi, while the civil authorities, the kings, come out of the tribe of Judah. Separate offices, separate functions. But both are established by the law of God, and both are under the authority of the law of God. So the display of the Ten Commandments, I would argue, is a display of the symbol of the political philosophy of the founders of the United States and of much of Western civilization, and that their display, therefore, is not an establishment of religion and does not violate the First Amendment. And with all of this, I think it is entirely appropriate that the Ten Commandments to be displayed. We'll see what the voters of Alabama think, then we'll see what the courts think. But we'll have a lot of opportunities to educate in the meantime. And I was going to go till 12, and it's 2 minutes after 12, so rather than take questions, I'll be glad to talk about this with anybody who'd like to stop by the office at any time, or if you want to just talk with me informally afterward here today. Anyway, thank you so much for the opportunity to be with you, and thank you. I'm sure you all are grateful to God that He has given you the privilege of receiving a kind of education here. You have no idea how your professors here, most of whom were educated under secular systems of legal education, you have no idea how much they have had to study to unlearn what they had learned before and learn the biblical philosophy of law that they are inculcating to you. I never had that. I'll tell you, of the things that I've said to you today, less than 1% of it I learned in law school. Be thankful that you have faculty that are giving you such a head start. And what we've started here, my prayer is that you will carry it forward and go way, way beyond anything we have done. Thank you, and may God bless you all.